Hello everyone, my name is Mehran Fardis. I am an immigration attorney based in San Diego, California, servicing the entire nation and worldwide with immigration questions, requests, and any immigration needs that you need help with. Immigration is my passion. I am an immigrant myself. I enjoy doing this. This is more than work for me. This is really something I look forward to every day. Today we're going to talk about a topic that has been coming up lately quite a bit for me, and that is a K1/fiancé visa. I get calls from a lot of people in US or outside US asking me how they can bring someone to US as a fiancé. So let's get right into it. Fiancé visa is designated as a K1 visa under the USCIS notation rules. So K1 is the fiancé visa for immigration purposes. A fiancé visa is considered an immigrant visa, meaning the intent of the person coming to US would be an immigrant. It's not a tourist visa or an employment visa, so it's designated as an immigrant visa, and I'll explain to you why that matters shortly. So to start the process, the petitioner inside US, petitioner is the US person asking immigration services to provide benefits to someone coming from outside US, that would be the beneficiary, to get a visa. To start the process, the petitioner will file a form called 129F. It's a pretty short form considering immigration forms are pretty long, but it does have a lot of detailed questions. Some of the check marks on immigration forms are tricky, and it is very important to answer the questions truthfully, correctly, and as they are. It is very important not to provide incorrect information to USCIS, not only because it's unlawful, but also it creates a lot of problems. So to file for a beneficiary to come inside US, the petitioner needs to provide certain documents to USCIS to be eligible to request to receive this visa. So the visa is given to the beneficiary outside US. So the process starts with the form 129F. What do you include in the form? There's several things that are important to include in the forms. Number one, you have to provide that you supporting documents that you two have met in the last 2 years. There's a 2-year meeting requirement. People talking on WhatsApp, on chats, on videos. You have to have met in person. That's a requirement. There is a waiver for that, meaning there is a way to ask USCIS to waive that requirement, and I'll get to that in a second. But for the most part, you do need to have met. How do you show that? Tickets, hotel bookings, travel plans, pictures. That's how you show to USCIS that you have met. This is the first requirement. It must be there. Number two, there is a one-page declaration needed from either side. People need to write in their own words. Immigration wants to see if things are real. So they want people to write in their own words how they met, under what circumstances, how often they speak, and the nature of the relationship. It needs to be signed. It's a declaration both parties have to provide. In addition to that, you have to obviously pay USCIS the fees. Right now, the fees are $535. They might go up soon. And additional supporting documents. If one person was married before, they need to show that they're no longer married. This happens a lot, that people don't provide prior divorce documents. Court disposition is what USCIS calls it. You need to have court disposition clearly and unequivocally presented to USCIS, so the officer reviewing this doesn't have any doubt this person was married. These are the essential documents. On top of that, you can add other stuff. I wouldn't add too much fluff. This is really the base required documents. You need to have, you need to pay USCIS, you need to have the declaration, fill out the form, evidence of meeting, and a couple of passport pictures. And this is the base requirements. Now, if situation is different, if somebody had prior multiple marriages, if somebody had things that are legally binding them, we need to know about it. An attorney needs to assess that matter. For example, the person coming to US, the beneficiary coming into US, and that's a general rule with immigration, it's not just for K1. Immigration Services, USCIS, Department of Homeland Security, does very thorough background search. They want to know if you have committed any crimes or have been arrested. So not only do they conduct their own research, they also ask you, have you been arrested? Have you had trouble with law anywhere, anytime? Some of the times, the crime or the conduct itself is something USCIS basically considers not a big deal. But not disclosing the information or misrepresenting information about it is a big deal. That's lying to US government, and they have very narrow tolerance for those type of situations. So if anything has happened in the past, we have to say it. The US petitioner also has some legal boundaries. If the US petitioner, for example, has been involved in certain crimes like kidnapping, false imprisonment, human trafficking, things that have to do with another person, and they're basically saying you bring in someone into US, is this an abuse or is this a real situation? So if somebody has had a history of that, sometimes those can be bars, and you cannot really file a petition for someone to come inside US if you've been convicted or have had a history of certain type of crimes. So it is very important to assess everything thoroughly. Make sure the form is filled out properly and the information is provided to the USCIS officer in a clear manner for the officer to see what it is that you're trying to do, and then proceed with the request. Currently, it takes about a year to 2 years for these applications to get processed. USCIS is behind a little bit. So the petitioner files inside US, USCIS officers at some point in the service center will review the application. Once it checks and passes their preliminary review, having the documents ready, they'll send it over to NBC. From there, it goes to the consulate or embassy of the person you're basically trying to bring into US. That person will have an interview with the USCIS officer at some point. Once the interview is granted, the beneficiary who is coming into US will get a visa for 3 months. That person can come into US. Once they're inside the US, the two people can spend time with each other, get to know each other, and if they are a good match and they like to continue the relationship, they are allowed to get married and file for adjustment of status. At that time, there is no additional step needed. They don't need to file the I-130 at that time. They go basically to step 2 of the adjustment of status once the person has received the K1 visa. So you just go through with I-485, 765, 864, and if I-131 is needed or not, we'll have to assess the situation based on that. So this was a short review of K1 fiancé visa petition to bring your fiancé from outside US into US. I provided the base documents. Indeed, usually we add more stuff depending upon the situation. We have to assess every case on a case-by-case basis. I hope this was of help to you. This is a common matter coming up right now. So if you have any questions, if you need legal help, contact our office. Our phone number is below. My email address and website information is also present for your reference if you need to contact me. Have a great day. Talk to you soon.